To expand their spectrum of activities, many international non-profit organizations reach out to foreign countries like Germany. This is often a wise step, but also a step that has to be well prepared. And in this video, I will explain the German law non-profit organizations have to observe when planning to come to Germany. Great to have you here. I'm Stefan Winheller, a German specialist attorney for tax law, and my colleagues and I have been working in the field of non-profit and non-profit tax law for many years. But let's start with the first question, which is, what typical legal and tax issues arise in Germany when a non-profit organization considers coming to Germany? Well, amongst others, some of the main questions are the required capital stock, the extent of personal liability, the composition of the membership and shareholder basis of the German entity, the possibilities of exerting influence on the German subsidiary, and the administration and management of the German entity. And besides all that, the question of how the organization will be treated by the German Revenue Service is one of the most relevant ones, but at the same time one of the most difficult ones. The reason for that is that the German non-profit tax law grants exemptions from many different taxes and simultaneously levies taxes on business activities, which is similar to a non-profit organization in the United States, for example, where you would call this tax the unrelated business income tax. The questions just raised go hand in hand with the question of which legal form an international non-profit organization should choose for its market entry in Germany. Typically, there are three common ways. The organization can either have a representative office, it can have a branch office, or it can set up a separate legal entity. And at first sight, the representative office or the branch office is the easiest way of expanding to Germany. It simply means that the organization's staff is active in Germany as well. On second thought, however, this can lead to some serious legal and tax problems, because neither the representative office nor the branch office is a separate legal entity, and therefore the full liability for its activities in Germany stays with the foreign organization. Also, foreign organizations that run a representative office or a branch office in Germany, well, they tend to stay here and potentially establish a so-called permanent establishment from a tax perspective, which means that it will be subject to German corporate income tax because a permanent establishment is not eligible for tax exemption under German law. In most cases, this means that neither a representative office nor a branch office is suitable for market entry in Germany. So, what should you do? The most common approach for international organizations engaging in Germany is incorporating a separate legal entity, like an association, a foundation, or a limited liability company. And by far the most popular German type of a separate legal entity is the GmbH, which is a limited liability company similar to an LLC or a limited, which you are maybe familiar with from your home country. It just needs a minimum capital of 25,000 euros and can be found within a few days or weeks. And you can also choose the small version of a GmbH, which is called UG, for which you just need €1. So what you need for setting up such a company is at least one shareholder, which usually is the foreign organization itself. And the good thing about a GmbH or a UG is that the liability is limited to the company assets. Shareholders can be held liable only in very exceptional cases. And even better, the shareholders' assembly appoints the managing director who has to comply with the shareholders' instructions. Therefore, the shareholder has the absolute power over its subsidiary, which in most cases makes the GmbH or the UG the ideal legal entity form for foreign organizations. But can a GmbH or a UG be tax exempt? Yes, of course it can. Like other legal forms as well, a GmbH or UG that pursues privileged goals like charitable, religious or public benefit purposes, they can apply for tax exemptions with the competent tax office. And once granted tax-exempt status as a charity, the organization does not have to pay taxes on its income that is related to its privileged goals. And in general, it's also exempt from property taxes. And depending on the facts and circumstances, it may as well be eligible for several tax reductions or exemptions concerning the VAT, the value-added tax, which is a tax similar to the sales and use tax in the United States, for example. I hope you enjoyed this video. For more information on this topic, just visit our website and feel free to subscribe to this channel and activate the bell so you will not miss any of the upcoming videos. And if you have any questions about setting up a legal entity in Germany or about the possible tax exemptions, you're more than welcome to contact us. We have done this for many, many years and would be delighted to support you and your organization as well. Thank you.